Welcome everyone to our Lunch and Learn series. Today we've got Mike Moore and Wayne Young going to talk to us about some new laws that are coming through and those that didn't come through and what those mean. We wanted to go through just a few things. If you want to chat with us today and ask any questions, do so through the chat feature. Just type in a question to everyone and then we'll answer that, or you can type it in to myself as the presenter. Also, if you want to watch any of our pre-recorded Lunch and Learn series or anything that we've done in terms of education and webinars, you can go to the website that I have listed. It's our YouTube channel, and that has all of our archives. And then we also, of course, send out news alerts. I'm sure you guys have seen those. If you want to access something from the past or you remember reading something but you need clarification, you can go to our website, fridayfarm.com/news, to click on the labor and employment tab, and those will be all your the posts that we've done. And then to read any COVID coverage that we've done, and maybe you need to access past articles, you can go to that as well, fridayfarm.com/coronavirus. So today we've got we have Wayne Young and Michael Moore. Michael Moore is going to kick us off today and introduce our new partnership that we have.
Hey, thanks, Tabitha, and welcome everybody. We really enjoy doing these and want to keep being in a position to bring y'all good, timely information on a regular basis. I wanted to do Lunch and Learns for a long time, and COVID just provided us the opportunity with Zoom to be able to do those things in an easy way. But one of the announcements I want to make today, and this is Tabitha's got a big social media rollout for this, but y'all are the first to know outside the firm. We have recently, just as in 10 days ago, joined the Employment Law Alliance, which is a worldwide network of law firms that represent employers in employment matters, and all those firms have access to lots of other specialties, and we're really excited about what it's gonna offer us in opportunities to provide other resources to our clients. So we've got just a short, please, I usually hate these things, but hang with us for just a minute and watch this little video, and then Wayne and I'll get started.
Welcome to the ELA. The ELA is the largest and most prestigious network of employment labor lawyers worldwide.
As a client of an ELA member firm,
your organization receives the benefit of access to the world's largest
and most prestigious network of labor and employment lawyers
in the best law firms around the globe.
Members have been selected after participating in a rigorous selection process.
And only the very best from each jurisdiction are invited to join.
Clients of member firms
benefit from a global network reach
with direct access to local expertise in more than 100 countries.
And while the primary focus of the network is to help clients solve important labor and employment matters,
our full service members also have local expertise in many other areas of law, including data privacy, trade secrets, real estate, investigations, mergers and acquisitions, and countless other corporate transactions.
So whether your legal matter is in North Dakota or South Korea,
Argentina or China,
from Denmark to British Columbia,
anywhere in the world, you have access to local experts to help address your legal matters.
Here's a few words from our global team members on what makes the ELA so strong.
The ELA is all about quality,
commitment,
reputation, passion,
the best firms in the world.
Together.
It's a team.
It's a team. We're a team.
We are a team.
Local experts.
The best advice.
Together, we have global reach.
It's what we do.
It's what we do. It's what we do.
Anytime.
Anytime. Anywhere.
Anywhere.
Around the globe.
Clients first and always. It's that simple.
It's that simple.
It's that simple.
But so powerful.
Really
Powerful.
Absolutely.
No question.
We are the ELA.
We are.
All right, cool. Thank you, Tabitha. Again, welcome everybody. Wayne and I wanted to do a kind of a legislative update today in a legislative session that was pretty unbelievable, according to some of the folks that I talked to that were over there day after day, and a lot of things were proposed that didn't get passed. But we want to talk a little bit about what went through, what didn't go through, because the legislature really hadn't adjourned yet. They're going to come back, and there's not much telling what will happen. But I'll let Wayne get started. And like Tabitha said, if y'all have a question, send it in chat. If you don't want everyone to see it, then send it either to Tabitha or myself or Wayne directly, and we'll go through the questions before we get finished. Love to have them as they come up, though, if you do that. So Wayne, go ahead.
Thanks, Mike. Appreciate everybody joining us this afternoon today. And so, like Mike said, it was a bizarre session in a lot of ways. They're all unique as we followed them over the years. But with an overwhelmingly Republican legislature, with super majorities basically in both chambers, and in the Republican in the governor's office, you would expect to be a fairly pro-business friendly environment and a pro-human resource friendly environment. And that wasn't always the case. There were some things that the human resource and legal employment law community certainly raised an eyebrow at and opposed, and things that were brought up, and some of those passed, and some of them ended up passing in forms that were much different than when they were introduced. And so it's important to understand all those distinctions. And so, like I said, be careful to listen. We'll try to highlight the few things that we talk about probably near the end that did not pass, but were still relevant, because we foresee, as Mike said, that there's not been a final sine die adjournment, and there's still a possibility some of these things could be resurrected before the session is officially brought to an end. So kind of ease our way into it, kind of dip our toe into it with some fairly non-controversial things that passed that are relevant to the HR community in particular. Senate Bill 31, which is now Act 319, it did pass. It's an educational requirement for all the high schools in Arkansas to conduct a career readiness assessment for all high school graduates, and then provide them a corresponding certificate that readiness assessment has been conducted, and so they'll have that. So if you're hiring someone, I don't know if this will start in the 21-22 school year. It could, depending on the effective date, it could be the following school year, but just be aware that the high school graduates that come out in the next couple of years should have a certificate of career readiness, that they've done a career readiness assessment. And so that we think that'll be a positive thing for workforce development and workforce readiness in the state. Senate Bill 99 is now Act 97, so it also did pass. It establishes a pretty thorough and rigorous, as I read it, set of criteria for regulating the protocols for what's called step therapy in group health plans. Now, I'm not, as I like to joke, I'm not a ERISA benefits lawyer, but I stayed at a Holiday Inn last night. I know enough to know that there are oftentimes group health plans have what's called step therapy protocol, meaning that before you're allowed to, before a medicine or a medication might be covered under that's more of a new or experimental nature, you have to take some other more well-recognized therapy or medicine and then demonstrate that that's not effective before the medicine that the healthcare provider recommends, that's invariably more expensive, will be covered by the plan. So this sort of creates some criteria for when and how those type of plan provisions are going to be when they're permissible, and what limits there are on the group health plan to be able to regulate or be able to establish a step therapy provisions and protocols. So just be aware, if you have a group health plan that has step therapy as a term, just be aware that there's new regulations on that, and your broker your benefits attorney, whoever advises you on those matters, will need to be aware of those and to determine if any amendments to your plan are necessary. And then the last one that was sort of eye-catching to us, that went through without as much fanfare as I would have suspected, is Senate Bill 341, which is now Act 612. And it prohibits collective bargaining by public employees, including teachers, by the way, with the only exception being the police and firefighters, which have a lot of their own statutorily established, and they have their own unions in a lot of jurisdictions, and statutorily established guidelines on civil service proceedings for them, for police and fire. But for other public employees, and teachers is squarely, in the crosshairs there. It prohibits any sort of a public employer from officially recognizing a union as a bargaining agent for any designated group of public employees. So that's significant. We always knew that Arkansas was very much a pro, right to work type state, and something where we didn't see a heavy population of organized employees, not a lot of labor unions in the private sector. This is just more indicia of that, like I said, the legislature is more acute to those issues of organized labor, and has outright prohibited collective bargaining for public employees outside of police and fire. We'll see if there's that draws any court challenge or NLRB challenge, et cetera, if that's what the outcome of that will be. So we can't go too much longer without talking about COVID. So we're gonna switch, and Mike's gonna lead us off talking about a few of the COVID bills.
Yeah, and I want to follow up on that. Act 612 is, as anti-union as the Arkansas Legislature is, the current administration in Congress in Washington is pro-union, and so we can expect y'all can expect a lot of news alerts over the next 6 months from us about what's new and different at the NLRB, I suspect. So I want to jump in and talk about House Bill 1547, which is now Act 977. This is the bill that prohibits public employers from the state or local governments from requiring people, including their employees, to get vaccinated. It allows for a state-owned or a state-controlled medical facility to apply for an exemption, and it lasts. It is in effect until 2 years after the final approval of a vaccine and the removal of the emergency use authorization. Luckily, we got it limited to public employment because it originally would have prohibited all employers from requiring vaccinations for their employees. So if one thing I'd ask people to do, put in chat either directly to me or group, have you required your employees to get vaccinated? I just want to take the poll because people ask us all the time, are people requiring people to get vaccinated? I got to tell you, when I went over to testify at the legislature about this bill, I was shocked with the level of anti-vax sentiment in the legislature, and of course, as I'm sure y'all have seen over the months, that's a pretty broad spectrum of folks who are what I call anti-vax. I don't mean that to be dismissive of them, but it's been surprising to me. So it looks like, from what I'm seeing, highly encouraged, offering PTO, but nobody's actually required it. And so one report here is that 40% of the people have been vaccinated. I'll tell you that in our workforce, we're probably in our firm, we're probably over 75% vaccinated right now. And so I would offer for those of y'all who want to do further encouraging, there are a number of videos that are available. I think you can link them on the state chamber website. And if you can't find them, they're good educational videos. If you can't find them, email me and I'll send them to you. There's a response for somebody that says employee education got us to up to about 80%. It is the misinformation on vaccination is strong and broad. And so the way I think you do that, thank you, Tara, for putting that vaccinatethenaturalstate.com. There are good educational videos and information on there. We did some of that with our employees and it's helped, and it's obviously helping some of y'all. So we dodged the bullet on House Bill 1487, it's not tying our hands. I do want to follow up before I turn it back to Wayne about the benefits. You know, we're considering, and I'm advising a lot of people that at some point in time, we're going to be able to say vaccinated people don't have to wear a mask anymore. Unvaccinated people do. And, you know, as we'll talk about it in a little bit, what Wayne's going to talk about, the CDC guidelines are so important for everybody to keep up to date on, and they change all the time. I had a partner of mine email me yesterday morning before we had a meeting. He said, can we meet without masks if we're all vaccinated? And I looked, and the current CDC guidelines are yes. So it behooves us all to stay up to date and have that CDC guideline website bookmarked on your computer so you can get at it as quick as you can.
That's exactly right. That's directly relevant to the next bill we're going to talk about, House Bill 1487, which is now Act 559. Recall back last year in the spring, if you dare mentally take yourself back there, the governor issued a series of executive orders that were relevant to things like civil immunity from suit based on COVID exposure and also workers' comp. And so the legislature came in and sort of codified, put in the code a lot of those executive, what were, you know, beforehand, just executive orders that the governor had promulgated under his authority under the state of emergency. So those things are now these things we're about to talk about are now part of the permanent Arkansas code and have the same effect as any other code provision. So Act 559 does exactly that. It provides for civil immunity from tort liability based on alleged COVID exposure on a business premise. There are two exceptions. One is workers' comp, and we'll talk about that on the next bill. And the other is willful conduct. And the statute goes on to define, it says there's a presumption that an employer is not engaged in willful conduct if they're following the CDC guidance, State Department of Health guidance, or CMS, the federal CMS guidelines on COVID exposure. So all the more important, going back to Mike's point, to know what those guidelines are, because it sort of creates a safe harbor for you from any sort of allegation from a third party, a customer, a vendor, that they've been exposed to COVID in your place of business, your work site, and try to create some sort of tort liability or civil liability on account of that. So we've had questions come up beforehand, things like, what about business meetings, as Mike just alluded to, or large gatherings. I've seen some social media pictures anecdotally of there's starting to be some additional larger meetings and gatherings of folks. And so, what sort of things should you consider? I think you should look at this statute and know what the guidelines are. We're seeing things like waivers that are signed by participants in large group meetings where they acknowledge the inherent risk of contagious disease, including COVID, and they agree to waive any sort of or release the premises from any sort of liability based on a claim that they got COVID while they were on the premises. And so, you might consider that, but first and foremost, I would say is if you follow the CDC guidelines, this statute in Arkansas would provide you some comfort that you're going to be immune from tort liability for suit because of that. Mike, anything you'd add to that?
Yeah, the other thing, one of the questions we had is about the local mask mandate in Little Rock. So it might be a good time. I think that applies only to public gatherings where you can't socially distance. And so I would not take that to mean that a private office situation is where you're required by the Little Rock mask mandate. And there are different ones in different municipalities. And of course, as some of us know, some places in Arkansas don't much believe in the masks, and that's just a different culture, different places. But if you want to be like Wayne was saying, if you want to be immune, then look at the CDC guidelines.
We talked about workers' comp, and I've gotten this question a few times in the last year. What about a comp claim, for COVID exposure? So House Bill 1488, which is now Act 353, addresses a lot of this. As you might know, any conduct by an employer that's considered intentional, that is not covered by normal comp rules. And so the first thing the statute did was very important. This new bill, it provided that simply requiring employees to work in an in-person environment where there's a known exposure or potential exposure to COVID, that doesn't mean that any related subsequent COVID was on account of the employer's intentional conduct. And so that's important, because if it's intentional conduct is outside the scope of comp, and the employer can be sued directly. And so hear me again, if an employer is requiring folks to work in person or in an environment where they know there's potential COVID exposure, that is not intentional conduct. So it is covered by comp to the extent that there is a claim. It goes on the other side, sort of the coin, it exempts COVID from what's called an ordinary disease of life, which is ordinary diseases of life are ordinarily not covered by workers' comp. But COVID is sort of specifically and expressly exempted from an ordinary disease of life, such that it still could be an occupational disease. The catch there is that the employee would still have to prove that they were exposed and got COVID in the workplace through how they would otherwise have to prove, that they were diagnosed or got some sort of other occupational disease at work. So you still have to prove that it was an occupational disease that was work related in order to have a comp claim for COVID. There's a practice tip there is if you ever have an employee that makes that allegation that I got COVID and I know I got it at work, just complete the form, process it as a claim in the same way you would if they had alleged any other sort of work injury, and then let your carrier sort it out as to whether or not it's a compensable claim or not. The next, and I think the last COVID bill on the list here is, well, as it relates to COVID proper, is vaccine passports. And that's been a catchphrase we've heard through the news a lot in the last several months. Senate Bill 615 is now Act 1030. So it did pass. Similar to what Mike was talking about the vaccine requirement, this bill as originally introduced would prohibit any employer from requiring a vaccine passport as a condition of employment, which is effectively the same thing that House Bill 1547 purported to do. through some work with the sponsor and amendment, the bill now reads that basically a state or state agency, political subdivision of the state, shall not require an individual to use a vaccine passport in the state for any purpose. It can't be a condition for entry into the state, for travel within the state, for education, for employment, for other services. And that's for public, again, that's for state agencies, state entities, public, public subdivisions. I'd say that includes the school, public school districts. So, a vaccine passport, again, that's sort of been a hot button political item in other states. We've got our vaccine passport bill that only limits vaccine passport requirements for the government effectively. So basically in line with what Mike talked about in House Bill 1547 as we were able to get it amended. So Mike is the guru on all things unemployment, and there were certainly some significant unemployment developments both at the legislature and governor's office. And so we're going to let him update us on those.
Thanks, Wayne. Yeah, and I was thinking that I've been predicting, and I really don't think it'll be too long before a lot of restaurants are going to require a vaccine passport. They're going to require you to show your vaccination card to get in, because the employer, the restaurant clients and friends that I have cannot get people to come to work. And so they've got to find every method of being able to get people to come to work they can. And if they tell somebody, everybody who comes in is going to have been vaccinated, then they're liable to be able to get people to come to work. What y'all saw last week was that the governor decided that he's going to end the PUA payments, the $300 a week unemployment bump in June the 21st, I think. And as I bet most of y'all know, getting people to come back to work after COVID was difficult because a lot of people were making more money on unemployment than they were than they could have working because of the extra money they were getting paid. And so one of the strategies to get people back to work and to fill the jobs that everybody's trying to get filled is to disincentivize being on unemployment. And so that the governor joined the governors of Montana and South Carolina, I think, in doing that. There are some legislative efforts in Washington to do away with that $300 a week bump and pay a back to work signing bonus, if you will, which will incentivize people to go back to work. There are a lot of other considerations that people have in not wanting to go back to work, whether they're kids at home, remote school, whatever. But this is one of the ways that will help get people back to work, I think. So a couple of other bills that passed at the legislature dealing with unemployment are House Bills 1407 and 1409, which are Act 369 and 368. How they got out of order, I don't know. One of them is the Act 369, which sets a different floor on the stabilization rate. And so what the legislature is trying to do there, stabilization rate allows during higher periods of unemployment for a higher unemployment tax to y'all as employers to keep the unemployment trust fund up at a good level. And it's now at, I think, $795 million, which is the highest it's ever been. For those of y'all who lived through 2008, 2009, it was negative 360. The trust fund had to borrow hundreds of millions of dollars from the feds, and it cost y'all hundreds of millions of dollars in extra unemployment taxes. So they've adjusted that stabilization rate to better react to the unemployment situation. so that we can keep that rate high. They also raised the taxable wage base to $10,000, which I think it would have raised to that anyway, based upon 2 years ago, we at the legislature lowered the minimum taxable wage base to 7,000, which is the floor required by the feds. And so that taxable wage base is now $10,000 for this year going forward, and hopefully as the unemployment goes down, it'll drop back down to 7. The biggest thing that happened in unemployment at the legislature this year was House Bill 121, which became Act 153. And what that does is allow the DWS director in their discretion to non-charge employers for unemployment claims during COVID, which means all of the payments that were made to your off work employees from April 1st to the end of 2020 are not charged to your account. So your experience rating will not go up unless there was something that happened before April 1st that caused you to have a lot of claims. So all of those claims are non-charged. And so as you start getting your annual unemployment statement, which gives you what your rate will be, you need to check to make sure that happened, because as I bet some of y'all know, the folks over at DWS have been somewhat busy the last year and a half and have been so swamped that they can't keep up, as you may read in various news outlets complaining about their not being able to keep up. One of the other things that happened, I think, is that they now have the ability to get funds from federal sources and state sources, which are going to finally allow the unemployment system to be upgraded, where we're going to have a much more streamlined claims process and appeal process that will lower the burden on y'all doing that.
Mike, do you know
process claim.
on the non-charges, does it have to be, is it all claims, or is it just claims that are COVID related, so to speak? So what if you had an ordinary, I say a non-COVID related employment loss that was deemed not disqualified? Is it all claims in that time period, or just COVID related?
Yeah. So the way I understand it is, if the claim was made before April 1st, then the benefits paid on that claim after April 1st are still charged. But this is any benefit claimed after April 1st, because there was no way they had the manpower to go through and try and determine, is this a COVID claim or is it not? Yeah. They don't have the manpower to determine any of the claims they got right now anyway. So it will be a wonderful windfall to employers. Now, the problem with that is that there's going to be that's going to cause a drop in the trust fund balance, because those are claims that are going to be that were paid but don't get replenished by increased tax rates. So, question: will people who choose not to work out of fear of contracting COVID be eligible for UI benefits? And I think currently a subjective fear is not going to get somebody out of it. What we've seen a month or so ago, maybe 6 weeks, the Arkansas Court of Appeals made a decision in a case where a lady quit her employment at a car dealership, and she said, I quit because my employer was not following CDC guidelines. weren't requiring masks, weren't requiring social distancing. I complained about it and they wouldn't do anything, and I quit. And Arkansas Supreme Court said that is good cause for quitting, and you are entitled to unemployment. So subjective fear of contracting COVID, not enough to get unemployment. But if an employer can't prove they're following CDC guidelines, and that causes an employee to either quit or not come back to work, then they will keep drawing their unemployment benefits.
I think that employee even had some additional circumstances, such as a vulnerable family member at home or something. It wasn't,
Right.
It was just a really a perfect storm of a fact pattern for where you could say, well, in a general sense, yeah, I mean, subjective fear of contracting the illness is not, but if you got an employer that's not following guidelines and you've got some vulnerability yourself, or a family member or at home, or a roommate, or someone in your sphere that's vulnerable, and you don't want to expose, that's where I think those facts could add up. So that's just all the more reason, again, to stay diligent with the guidelines, keeping up with, number one, the most difficult thing right now might be keeping up with what they are, because they're so dynamic and fluid and changing. But again, I think if you had a claim in this situation where someone was claiming a fear of the virus, but you could demonstrate, look, here's our COVID protocols and practices for both staff and vendors and customers and visitors on our premises. I think it'd be very difficult for an employee to be able to prove a not disqualified scenario there for a claim if all they had was just, well, yeah, I'm just subjectively afraid of contracting the virus, and that's all that was said in a vacuum.
So the question about the governor's about the bill to ban local mask mandates. I'm not sure whether there was I'm trying to look while we're talking to see whether there's an emergency clause on that. Was there, Wayne?
I don't remember. I feel like there almost would have had to have been for it to have been meaningful, to have an emergency clause. So, a lot of times those bills will set an effective date and then have an emergency clause, so that they're triggered by an effective date, and not ordinarily it's 90 days after adjournment, sine die.
And so I would, in the report I saw, I think this is accurate, that it says it won't take place until at least July, which means it's 90 days sine die. And that would mean that it's going to be a while, since they're not going to come back for a while and adjourn. So yeah, I would hope that if we're talking about something that's 120 days to 150 days from now, it's not going to be a concern. But by then, the mask mandates will be gone. And it does not affect whatever a private business does. So will new claimants prior to June 26 who are being laid off for summer break, not COVID related, receive the $300 until it ends in June? I believe so. The $300, I think I saw that it was June 21st. It may have been June 26th. But that's when the PUA benefits will stop.
Real good. We still got a few minutes and continue to chat in with your questions. We're going to go over some, most of these are on the list. There's one I think that actually did pass. It's sort of a kind of a niche bill, but I just want to give you a flavor of some of the bills that were introduced that either didn't, some of these passed one chamber and didn't pass the other chamber, which ordinarily that's a flag for us, because that's something that had enough legs to pass one chamber, pass through committee in the other chamber, and get to a floor vote in the other chamber. Ordinarily, the sponsors of those top bills are thinking, hey, if I can tweak this a little bit, or I can politic a little better for those nay votes, and the chamber where it failed, or maybe those nay votes are turned out, or they're beat in, they're beat in the fall in elections. And so there's new people coming in. It got so close that you got to keep an eye on it as something that might rear its head again in a subsequent session. So one of those that I thought was interesting, again, getting back to, it's not always predictable, just the pro-business stuff passes and the anti-business stuff fails. House Bill 1050, and I'm not sure where this started, if this was a DF&A initiative or not, but as you may know, there's currently a threshold of 200, if you have 250 or more employees, you're required to file your annual income tax withholding statements electronically with DF&A. This bill, this House Bill 1050, would have lowered that number from 250 to 25. So you're basically, capturing all, mid-sized to small businesses. And that bill made it through the House and made it through Senate committee and then died on the Senate floor, and it was beat on the Senate floor. And so just be aware of that. If you're in that category there of more than 25 employees, but less than 250, if you're not currently electronically filing your income tax withholding statements, be aware that that's something that's been on their agenda. House Bill 1227, Act 591, just a real minor tweak here to state wage and hour law. It basically added an exemption from minimum wage hours worked, what I'll call hours worked coverage, for employees that worked for a motor carrier with respect to travel time to and from their personal residence, engaging in personal activity that's not in primarily of the furtherance of the employer's business, number 2. And number 3, I thought this was the most maybe relevant, logging time is, quote, off duty or in sleeper berth. And so that time now, under Arkansas, that's not obviously not a federal FLSA change. Under the Arkansas Minimum Wage Act, employees of motor carriers, if they're engaged in those 3 activities, that's not going to be counted as hours worked for minimum wage and overtime purposes. And so that may or may not be relevant to you if you're a motor carrier or have clients that are motor carriers. Another bill that didn't make it, that made it through the House, but did not pass the Senate, was House Bill 1349. And that was it was called the Every Arkansan Retirement Plan Opportunity. And the goal of this was to create sort of a federal state partnership. And they use the analogy in the text of the statute is with a 529 plan for college savings, where it's sort of administered by the government, but through private institutions and banking and investment institutions. It would allow private employers to voluntarily participate in what effectively would be a multi-employer group retirement plan that would be administered by the state in a similar way to a 529 gift plan is administered. And so the thought there is that employers who maybe didn't have the resources or the know-how to go out and get their own group retirement plan product through brokers or investors or the private market, they could voluntarily participate, have their employees participate in this government-sponsored Every Arkansan Retirement Plan opportunity. And so they could do it. So again, that was something, made it through House committee, made it through the House floor, made it through the Senate committee, and then failed in a very close vote in the Senate. So be aware of that as something, that you might, if that's something, if you don't currently have a retirement plan, and just be aware that's something that might be coming down the pipe for you in a future session.
Yeah, and again, Wayne, I mean, hey, for y'all, if some of these Wayne is talking about that didn't pass, or something that means something to you one way or another, call your representative and because it may well come up again. And
yeah. It will come up again this year, with status, some of these ones that were this close, for sure. House Bill 1851, medical marijuana, the medical marijuana law passed. I'm not going to go an hour and not talk about medical marijuana, right? So medical marijuana passed in 2016. And we had the implementing legislation in the 2017 session that amended the amendment and become, we're incorporated in the amendment. The most asked question I've gotten in the last 4 years about that legislation is regarding, what's a safety sensitive position. There's all sorts, there's different interpretations of that language and that definition. There was a bill filed this year, 1851, that sought to amend the definition of safety sensitive position to make clear that any employee that handled confidential business information or patient or client information, separate and apart if it was related to a criminal investigation or not, any handling of any confidential information would make a position safety sensitive. Now that bill didn't get it didn't get to a vote. But what I would tell you on that is stay tuned, that there will be, I think, some developments on that through other means where that definition might be clarified as it exists today. And we're obviously bird dogging that and making sure that we follow the blow by blow. But just, we had some conversations with the people that sponsored that bill and were behind it. And so there will be, I think, some development on that, even though that bill never got to a vote. So for those of you that asked that question, and like I said, it's the most asked question I get, I've got a position that handles confidential financial information, or I've got an employee that handles trade secret information, or a confidential client list, or account numbers, or protected health information. Are they safety sensitive? Stay tuned. There was a bill filed on that, and there's some momentum and traction for getting some clarification on that definition. So again, be aware of that. House Bill 1871. This is one that didn't get very far, didn't get out of committee, but I thought it was, as an HR attorney, it sort of piqued my interest, and so I want to make sure and talk about it. It's what's known as a Crown Act, and if you're employment law attorney or HR pro, you've heard of Crown Acts in other states. And basically, for those of you who might not have heard of it, it's just basically that it has to do with an employee's hairstyling, hair texture, things like braids and things that are associated with the particular culture and hairstyle being a protected characteristic for employment law purposes. So the way it would read is that basically employer could not discriminate against an individual based upon a trait that is associated or perceived to be associated with race, including an individual's hair texture or protective hairstyle. And it gave some examples of those things, including braids that were included as expressed as examples of a type of protected hairstyle. What I would tell you on that is that even without that law, there was a very easy argument to be made that if you let's just say the facts are as simple as someone was discharged because their hair style violated the dress code, if they could tie that hairstyle to a particular racial practice, religious practice, ethnic or cultural practice, it could be very easily made into a discrimination claim based on the law as it reads now in the Arkansas Civil Rights Act. So this certainly was a bill that would have made that express, but just know that if it doesn't mean that, okay, well, that means I can have an overly restrictive dress code policy on hairstyle without taking into account issues of religion and race and ethnicity. I'd caution you against that. I'd challenge you to make sure that if you're going to enforce a policy that's strict on hairstyle for a dress code, that you make sure that you've vetted it through council to make sure that if you've enforced it in such a way as to not be discriminatory based on race, ethnicity, religion, as the law reads now. A couple of other bills that again didn't make it very far. there's a representative in Northwest Arkansas, very nice guy, nice man, but he files a lot of very, what I call employee friendly wage and hour bills every session. And, you know, he doesn't have a lot of luck, but it's important to know sort of the types of things that, you know, at least one legislature is on their mind, you know, because it could lead to, you know, enforcement priorities by the State Department of Labor, or other things, you know, that do get some traction either in this session or in later sessions. And the one that really raised some eyebrows that he filed this year was Senate Bill 600. That's, you know, very innocently called just the Right to Know and Get Your Pay Act, which that's sort of, you know, oftentimes, and it's not unique to one political side or the other, but they put these very innocent and positive sounding names in the bill title, and then you read the bill and find out that, man, it's a lot more than what meets the eye in the title. So this bill, you know, he was, I think the point of it, as he described it, was to, you know, a lot of employees weren't really getting sufficient information on their pay stubs to determine if they were being paid correctly. I don't see a lot of that. Maybe I'm naive. Maybe I'm starting to hit my desk, but I don't, you know, we don't see a lot of employers that are just withholding, you know, pay stub information about hours worked, rate of pay, deductions, that are withholding that from their employees. And certainly if there was an employer out there doing that and using it to sort of defraud employees out of pay, they wouldn't follow this law anyway. So we didn't really, you know, we were struggling to find what the real purpose of it was, but it added a lot of record keeping requirements on employers that are neither under current law, there's already plenty under current law, nor were they required under federal FLSA record keeping requirements. And, you know, the one thing that was really, I thought, drastic that it did was it prohibited an employer. Again, this didn't pass, so don't get freaked out, but it prohibited an employer from changing the terms or conditions of employment without giving the employee a week's notice of those changes. So as an employment lawyer, the way I read that, it basically gave an employee an employment contract for a 1 week term on a rolling basis. Because if you hadn't, you had to give them 7 days, a week's notice before you change the term or condition. Firing them, changing their rate of pay, changing their shift, changing their schedule. And so obviously that was a huge red flag for the business community, for the HR community. And we did flag that and testify. I think Randy Zook even tested for the chamber, testified against this bill in the committee. Another thing that employers will shake their head at, you know, there is a statute, Arkansas Code Annotated 11-4-405. Employment lawyers have that memorized because for years it was the bane of our existence in trying to figure out what an employee was owed in terms of their quote unquote last pay after they were discharged. Does it include PTO? Does it not include PTO? What about things that, you know, liquidated debt or promissory notes that the employee had signed with the employer to repay a debt, or if there was property damage or cash register shortages on the employee's way out the door, could those things be withheld? So we amended that statute and really clarified and did make, it's not perfect, but it's a lot better now and a lot more clear, especially on the timing, that you don't have to issue a special payroll for a terminated employee. You can pay them when you would otherwise pay them for the pay period in which they were their last pay period, when they were discharged or separated or resigned. You can issue that check or deposit, whatever it is, on the next payroll that it would otherwise be issued. You don't have to issue come in and conduct a separate payroll just to cash that discharged employee out. This bill would have changed that and really taken us back, to the bad old days, as I would say, and would have required a discharged employee to be paid within 48 hours, regardless of when the discharge was. So I guess that means nobody gets fired on a Friday anymore, because if you get fired on a Friday, you'd somehow have to be able to get your paycheck on Sunday, which again, there was no exceptions for weekends. There was no exceptions for holidays. no exceptions for anything. Like if you fired somebody today, you had 48 hours to get them their last paycheck. So again, I love this representative as a guy, as a person. He's a good guy. He's really sharp. But some of this stuff, like I said, is very pro-employee. And again, bill didn't make it out of committee, failed on a committee vote. So we were happy to see that one anyway get defeated. But just be aware there are legislators out there that have that kind of there is not just this representative, but there are others that are, as Mike described, whether you call it anti-vax or not, there's a populist type of element that's really not necessarily pro-business all the time. A lot of times it's pro-consumer, pro-employee. So don't take for granted that your legislature is going to know, they're Republican and they're just going to vote for whatever's pro-business. Let them know if there's something that maybe you're in favor of the Crown Act, or maybe you're in favor of some, let your representative know your opinion on it and get involved, because that's those folks, they don't, if they respond to their constituents, if they know you're a voter and they're hearing, if it's important enough for you to contact them about it, I promise you they'll entertain the conversation with you and at least explain their position.
Hey, Wayne, there's a question in chat about the bill number on that last bill. And while you look for that real quick, I want to
Senate Bill 6. And I kept saying representative, the guy I'm talking about is a Senate Bill 600 is the right to know your pay, which included, and then the she could be referencing there, the statute that talks about an employee's last pay is Arkansas Code Annotated Section 11-4-405.
Yeah, and let me follow up just a little bit on that Know Your Pay Act. When it talked about all the different things that have to be on a pay stub, let me just give a really, really quick story on a best practice issue, because I just got a lawsuit in last week where it's a wage hour lawsuit. Imagine that. If y'all hadn't gotten sued on wage hour, you will, because everybody's getting sued on that. And this suit alleges that the employer paid non-discretionary attendance bonus and did not figure overtime into that bonus, as you're required to do. If you pay non-discretionary bonuses, you have to account for overtime in those. And the lawsuit says they didn't do that. Well, we get on a conference call with the client when we get it in, and they said, well, we do that. They said, it's not reflected on their pay stub, but I can show you our payroll records where it shows that. And what happened, what we're trying to do now is, I got one person saying I don't have any audio. I hope.
I can hear you.
Okay, that it's just one. So what I took from that is to think, okay, I need to look at my pay stubs to make sure that an employee who gets a non-discretionary bonus, it shows in there enough to let them know they are getting the overtime premium, because I promise you, it's going to cost my client more getting out of this lawsuit than it would have cost them to put it on that pay stub. So that's just a kind of a best practice. Avoid that lawsuit if you can. Kim, and I hope you were able to hear now. Anybody else got any questions or comments or anything they feel like they need to bring up? If not, please feel free to email Tabitha or Wayne or me and tell us of other topics that you'd like to discuss. We are really wanting to do this in a way that is meaningful to y'all, and we always want to come up with something that's timely and needed. So we appreciate all of y'all and appreciate your time. So let us know what we can do for you. All right.